here too well. I'm not a big car guy, so it didn't get me excited so much about cars as it did about product. And the thing about that ad that struck me is it didn't make me want to buy a Cadillac, but maybe make me buy a Cadillac. You see, how many buttons should a car have? How many buttons should a tablet? Kind of brings up an iconic image of the product that's been designed very minimalistically. Really great design, it's emulated and imitated. So that's kind of my controversy, the idea of value in design and other intellectual property. So the types of patenting, or the types of things for patents, trademarks, and copyrights. This is just a quick discussion of patent prosecution process. Patents is just a legal document to get intellectual property from the Patent and Trademark Office. They are an exclusionary right. It lets you stop other people from doing things, but they don't do that on their own. You have to actually sue to protect yourselves. It allows the owner to exclude others from making, using, selling, or importing into the U.S. and they expire 20 years from the date of application. I didn't put in that it lasts 20 years from the date of application, which is what a lot of people think. They expire. They really don't have any force information. Now, patent ownership, and this is something that comes up a lot in construction contracts. You'll have a core group of individuals with some really great ideas and want to build a business around it and own them. Under the U.S. Constitution, Congress has the right to give patent rights to inventors, not necessarily just to companies. So, as a first principle, all patents are owned by their inventors. Whether or not you made it for somebody else, they hired you to do it, your employer, you're contracting for somebody, it's owned by the inventor in the first instance. Now those rights can always be contracted away, but they're owned by the inventors. And with the co-inventors, and there's more than one on patent, you have an undivided interest in the patent, which basically means both of you own everything. And if there is falling out, one person can go one way, the other can go the other. I can sell the product, I can license somebody else with no right of counting to the other person, which means any royalties I'm able to get from a third party, I don't have to share with my co-inventors. We had a falling out or business fall, just as well. And that's one of the things it's important to look at when you're starting up a business and talking to the right advisors to help you out with starting up the right type of tenant that's going to give everybody the right protections. Now, assignment of ownership is typical in employee contracts, and those are my block. The first principle of the owner of the patent is the inventor. They can always sign it away, they can always sell their rights. The other thing is egos getting in the way. Improperly naming inventors on a patent can render the patent invalid. So there can be a case where you have more than one person who invented something working together. One of them goes files a patent on their own because they didn't involve the other person. The eventual patent issue might not be valid. The other instance is in a company where you have egos who want to be named on a patent but didn't really contribute to the invention. They were more managing the project. Those are discussions that you have to have up front and say, well, this is why we want to name these people as inventors and this is what's important. What dictates who is the inventor is going to be in the claim, so I'll talk about those a little bit. So there's three types of patents, utility, design, and plan. I'm not going to really talk about plan patents, unless people are grafting trees and wanting to sell them out. I think that's a whole lot for this crowd. Utility patents are by far the biggest group. This is kind of the statutory laundry list of subject matter that's eligible for utility patent protection. Machines, methods, manufacture, a manufacturer's article manufacturers, any product. Composition of matter is kind of chemical formulations and things like that. Systems are very broad. A system can encompass multiple physical objects put together to carry out, a complex function, or a system can be a multi-step process. And improvements to any of those things are patentable. Only patentable to the extent that you cover the improvement. So I can come up with an improved widget and patent it, but I can't patent the existing widget that somebody else already has. Now, one thing that statutory subject matter brings up a lot is software and other areas where it's more ephemeral and people, think, well, that's something that you can do in your own head. As lies, statutory subject matter does not extend to mathematical formulas, algorithms, or mental processes. So, just having software that does what somebody with pen and paper could do is not going to make that process patentable. There are separate standards for software, but that's going to be more than a talk Tyson's going to give later this year. Design patents are the next biggest group, and I think underused in a lot of ways, and are starting to get much more traction. They protect new, original, and ornamental designs, and I left off there on a useful article. So a useful article that might be patentable under utility patents, this is a way to go after the aesthetics. This is a way to go after the industrial design, the user interface, the way you see, the way people interact with it, that really can separate one product from another. Does not protect the functional aspects of an image. You get really fuzzy because a one-button interface on a flat tablet surface, what's the function? I mean, you're maximizing your for carrying out this, for making this product. A little fuzzy, but in general, when you think of it, a lot quicker. Your claims in a utility application are long blocks of words, sometimes a column on a piece of paper that in words tries to lay out the idea of what you're protecting. Here it's pictures. You have line drawings of an article. You put in solid lines those features that are claimed that you want to keep other people from doing. But you put other lines in dash or shading to show context, and there's some examples of that later on.
One thing I might note as well that for all the Apple things, Steve Jobs was a huge believer in design patents. And if you go and look at a lot of design patents from Apple or applications, Steve Jobs has his name on quite a few of these. For example, some of the Apple iStore designs. The iPhones were designed, design patents cover aspects of, pretty much anything in a lot of the Apple products. So, Sean, design patents are, big business.
So the next area are trademarks, and I'm going to talk about a couple of different areas of trademarks that people might look at as separate, but really kind of fall into the same, really do fall into the same heading here. A trademark is really anything that serves as a source identifier for a product or service. The big Omaha logo, analog to be a trademark. Anything that associates that product or service to the source. They have to be distinctive, whether that's inherent distinctiveness because of a unique symbol or word that's applied in a very different way than it normally is, or it's acquired as distinctiveness, which means it's descriptive of the product, but yet everybody is associates that word with a particular maker of the product. There's registered and unregistered trademarks. You don't have to register your trademarks to at least have some protection. Protection from trademarks is associated just with using them in commerce. There are benefits to registration. A registered trademark with the U.S. Patent and Trademark Office is enforceable anywhere in the United States or its jurisdictions. An unregistered mark is enforceable in federal court under the Lanham Act, but only in the geographic region in which you're operating. Now, with the internet and things like that, with web-based businesses, what your geographic footprint becomes a really big issue. You want to stop somebody in another market that you might not be selling your product or service into from using the same trademark and try and say, well, we're on the internet, so we're everywhere, but that's not always going to work. And if it does, it's only going to work after a very long and expensive process. Images. They are very distinctive when you walk into a home improvement store and you see a big roll of paint installation. That is one. Lots of others. There is work now on how do they adequately describe smells, tastes, and things of that nature that people are actually starting to register. And that's getting to be a whole new and interesting area for trademarks. Trade dress is another area of trademark law. It can be registered or unregistered. And there's two types: product packaging, product configuration. Product packaging, just like what it sounds, is what product is put into. It is generally assumed to be distinctive. That if there is something different about it, it can be inherently distinctive just because of the way it's, because of its unique features. Product configuration is a little different, and this gets into a little bit of overlap with design patents. Product configuration can include the industrial design. The difference between it and a design patent is that you can get a design patent without ever manufacturing an article, without ever selling. Product configuration, trade dress is only available to you if you're using it in commerce. That your product is configured that way, and that's how you're selling it. The other difference, because product configuration blends into functionality so much, the courts are really restrictive on it, which means you can only protect it if it's achieved what's called a secondary meaning in the marketplace. So that means that in the mind of users, actually, they associate looking at that article with the source of the product. I look at a tablet that's flat screen with one button, and I associate it with Apple. Now, that would not have been protectable as product configuration trade dress from day one because it hadn't achieved that secondary meaning in people's minds. So the way you prove that, of course, is with customer surveys and all sorts of other evidence that it's also very costly to get and protect. So a lot of times, a utility or a design patent is a more cost-effective way, both upfront in trying to protect it and later on in trying to get it. So this was, over the summer, and I have a blog, and I blog a lot about the Apple and Samsung case. And for these areas, it's kind of a neat one to look at. A lot of people have different opinions on whether or not Apple should have won, should have lost. But as far as looking at utility patents, design patents, and trade dress, all in one case with products that everybody has seen and had their hands on, this is great. So you've got Apple iPhone 3GS and Galaxy S i9000 from Samsung, two of the products that were involved. So here's said, there are two types: product packaging, product configuration. Top is the Apple product, the bottom is Samsung's. The way they package with black nesting boxes with foam surrounding the piece, that way even when you lifted things out, the cable management for the box was almost identical. So that was one of the contentions that Samsung had ripped off their product packaging items. And product configuration, also on that last slide you kind of saw, was the overall view of the devices. And then these are design hacks that were in play. And I found some images to kind of show the similar views of the Samsung product on the left and Apple's design hacks, or Samsung's product on the right and Apple's hacks. So on the top one, they're going after the one-button flat screen phone. And then you've got on the right Samsung's product. The next one is interesting because the second one is really going after the user interface. What I said before is the solid lines show what's claimed, and what they're actually claiming in that are the icons, the buttons, the outline, the speaker. That's all in dash lines. That's just what they're showing is a home row of icons at the bottom and a screen with additional icons for your apps or what have you up above it. And then the lower one is more for the case, the outer edge. And what that top and bottom one show is a strategy that I've used in design patents also, where with one article you might do several different design patents. The reason being there are different aspects of the design that are interesting, unique, and you want to protect. So in each one, you can change up which lines are dashed, which ones are solid, what surfaces are shaded, and which surfaces are included in the design that you're claiming. And that gives a lot of versatility to you. Somebody knocks off part of your design, you take out the design patent that covers that area. And then these are just some of the utility patents that were in there. And it's to kind of give you a flavor, I just gloss over a lot when you start, putting up 7-digit patent numbers, titles, especially when it's method and apparatus for displaying access and control and status information in computer systems. Things like that. What they get into really were the rebound on scrolling feature on your iPhone or iPad, that when you scroll past the active region of the screen, it pulls down, and when you let go, it bounces back. That was one of them. That's the bottom one. List scrolling is another one about having the tab on the side not actually be what you're. When you scroll down, you see the tab actually move in the opposite direction, kind of a natural scroll feature on a handheld device. So these are utility patents that all kind of came up in that case. I'm not going to get into too much detail, but just to let you see that in one product, the design doesn't just incorporate how it looks, but also how it works. And your UI, your ID, all of that can be really important to try to protect. So the remedies, damages, in the Apple case in California was, what, $1.3 billion or that was a sum. Yeah, this was actually the way damages are calculated, and these are for patent cases, not trademark. Lost profits are really, really hard to make. Everybody wants it. Everyone wants to say, my market would have been huge if it wasn't for them stealing my idea. And they want to have it. In practice, really, really difficult to prove. A lot of times, courts and juries just say, hey, this is speculative. We can't look back and calculate what your lost profits are. We can't say that 100% of the profits they made are attributable to what they misappropriated, because they have some other features in the product also lost profits are usually very difficult to get. What it usually comes down to is reasonable royalty, where a court or jury basically carries out a hypothetical negotiation and compromise. And they say, what would, reasonable business entities had agreed to, ahead of time for royalty, and apply that looking backwards. One thing that happens with damages, though, is if somebody is a willful infringer, which means they know about a patent, they know they infringe, and they don't care, they're just going to keep doing it, is that the damages can be triggered by the court. So that's where you get some teeth from bad actors. The other things that are available are remedies and equity injunctions, where a court says, no, you can't make and sell that anymore. Injunctions come in a couple of different flavors. There's preliminary injunctions at the beginning of the case, and there's final ones at the end. Long story short, it's very difficult to get injunctions. So in most cases, you're looking to have reasonable royalties, looking backward, and then having that as the settlement looking forward after the trial for your competitor's profit. So I don't know if there's any questions. It's real kind of basic. Tried to cut this down to a half-hour presentation so we could have time for lunch and questions. My email is up there. My Twitter is Connolly IP, and my blog is ConnollyIP.com. I'll put the slides up there, and be happy to answer any questions on that also.
I've got one question for you. In the example that you showed with Samsung, I believe, I don't know exactly where they're based, but they're either somewhere in Asia. South Korea. Okay, so South Korea, and you've got Apple here based in the U.S. So in case of that, the patent only applies to U.S. sales?
Yes.
Okay.
And the reason that is everything's territorial. Everything is, controlled by the sovereign government, wherever it is. So while there was litigation going on in the U.S. in the Northern District of California, there was also litigation going on in Korea, Japan, Germany, UK,
Australia.
those
Anywhere those major markets, basically.
Yeah. Any of their major consumer markets, they had concurrent litigation going on in those areas. A lot of people said, hey, the U.S. patent system is messed up. Apple won on its own turf. If you look at it, it was a mixed bag in South Korea, where Apple actually won on several of their claims there also, based on the patents they had gotten through the South Korean Intellectual Property Office. So it was a mixed bag there. It's a mixed bag, I think, in the UK, Germany. Apple won pretty handily. Yeah, they're territorial rights that have to be enforced in the courts in the jurisdiction where you want to. So when you're going through the whole process of getting patents, just kind of gives me a good reason to talk about that, is you want to look at the markets. You're most likely definitely want to file in the United States. And you can file here first. And then under the Paris Convention, which is a treaty that just about every major country world is a party to, you have 1 year to file after you file your first application in your home country, file a patent application anywhere else that claims priority back to it. And what claiming priority back to it means is, I take that application, I want to file it in France. France will accept it and treat it as though it was filed on the day I filed my U.S. application. So for prior art purposes or anything else, it's as if I filed it there. I don't have to worry about things that other people have done in Europe. There's also patent cooperation treaty, which lets you file kind of an omnibus patent application that covers most, but not all, Paris Convention countries. In which case you file a PCT application 1 year after your U.S. filing. And then you have another 18 months after that, so 30 months total to decide which countries you want to file. And that's a great tool to use because it gives you a lot of time to figure out, one, which markets are important, and two, which of those can I afford to file. And do I want to spend that money and try and get passes? Keep in mind that it's going to cost money to enforce them also. So there's a lot of strategy. Do I want to stop somebody from making, using, selling, offering to sell imported. In the U.S., well, nobody's making iPhones, but they are imported. So I want to patent those features, but the idea that I'm protecting the consumer market, but you know, there might be a small country in Asia where they manufacture an infringing component that then gets shipped off to somewhere else to be assembled. Would it make sense to file an application there? It might. And those are things that they have to think of. Yeah.
Regarding the unregistered trademark, for a company that's pre-revenue, does that have any teeth at all?
Pre-revenue is very different. The reason being, you only have rights on a trademark once you're using it in commerce. And so it has to be associated with goods, with services. You can file, and a lot of times with pre-revenue companies, I encourage them to do this. You can file a trademark application pre-revenue, and it's called an intent to use application. What that is the trademark office will take it and act as though you're using it. They'll examine it against other trademarks. They'll give you that filing date for your trademark. But they won't issue it, they won't register it until you have an affidavit of actual use filed. And so it kind of gives you a parking spot to put the logo, the name, whatever it is that mark you want to protect as part of your business plan before because you want to use that when you're going out and marketing and raising money. But you don't want anybody to screw it up. So an intent to use application is very useful.
Okay, also very quickly, I would suggest that for tech startups, that year to bridge from a domestic patent application to an international goes very quickly.
It does.
It's not very long, really.
It's not very early in the process. And that's why I always recommend first a original application. There's cost reasons, but there's also some strategic reasons. What a provisional application is, it's an application you give the Patent and Trademark Office and they will never look at unless you decide to file a non-provisional application. And you have 1 year to file that non-provisional application. You don't have to worry about formalities, you don't have to worry about perfect drafting, you don't have to worry about quality of your drawings, you don't have to hire a professional draftsman or anything like that for a provisional application. But you still have that 1 year period. Now, that application will never be published or made public unless you claim priority to it with another one. So, say you're at month 9, and the product development hasn't reached a stage where you're prepared to file a non-provisional application. You don't have the finances to do it, but you're not aware of any competitors that have come along in the interim period, and you're not worried about somebody stepping in and taking the idea already. You can refile that provision. Now you lose the earlier days, but you can restart that clock. And because that first one was provisional, it'll never publish, you don't have to worry about it being prior. So as long as you feel like you're still secure in your place as far as being the first, inventor to file it, you can do that and reset the clock.
Yeah, there's a lot of questions I get with startups are website driven. Their first top of mind every startup is what a website can be.
Yep.
And so, can you talk a little bit about how that interplays with trademarks and find out somebody else has a domain like yours, and how you can protect it and get the domain you want to protect that domain?
Yeah, it's an area I don't practice a lot in right now, but UDRP is Universal Domain Name Dispute Resolution program. What happens is if you have a registered trademark and somebody else picks up a domain name, cyber squatting on it, or is disparaging your brand using it, and there is a risk of confusion, you can go through, does it go through WIPO or is it
Don't know.
International WIPO, which is the Worldwide Intellectual Property Organization. So you don't actually take them. You take them basically through people who register domain names across the globe and say, that domain that's been registered is interfering, it's going to be confusing with mine, and it's by the way, here's my registration that shows I have the rights of the trademark. So I want to register something with Coca-Cola in the name. You can be sure I'm going to get a UERP notice pretty darn quickly, even if I'm just trying to resell bottles of Coke that I picked up at Costco. Even if it's descriptive of the products I'm selling, they have that trademark bottled up, and no pun intended. And it's they're going to be able to take get that domain name and take it down. Yes.
So as long as it's trademarked, you can kind of get around people who are squatting on domain names.
You can. It's as long as you had the registration before they had the domain. So it's not like you go shopping for, man, I want this killer domain name, you find it, and somebody else already has it, so you go and register the mark. That's not going to work. And if they have a bona fide use of that mark in commerce, you're not going to be able to stop them. It's really tailored towards people who are cyber squatting and trying to extort money from trade. Yes.
Question about protection of business models and business concepts. I'll use Groupon to kind of frame my question. So Groupon came out with the innovation in the marketplace and spawned tons of copycats.
Yep.
Is there a way to protect against that sort of, protect your model, so to speak?
Yes and no. It's very difficult with utility patents to do that now. There are a lot of business method patents that are out there that people have tried to enforce. When e-commerce, first really hit the ground running, there was no case law for statutory subject matter related to that. And so there's been a lot of refinements now to where we have business methods that are out there that might not be valid, that the patent office probably wouldn't issue now. And protecting a business model like that would be very difficult. Especially if it's a business model that can just be carried out off the internet, that wouldn't really make sense. So the way to do that is really being, first to market. Groupon has probably the most identifiable name, even though they've been copied so much. And they're really kind of being the first mover advantage that is there. But that's really the main way that they're protected, is by your trademarks being associated with that business model, and just being the first mover in the market.
Ideally, you want to protect it with the utility patent, but there has to be something new, non-obvious in order to protect, provide you those exclusive rights. Copy.
Sean, we have a lot of our customers, but they don't do patents or trademarks because it's so cost prohibitive to protect them, protect against them. What are some of the strategies you guys implement on for entrepreneurs on a local budget to essentially get there without a huge expense?
Yeah, we do. We do a lot of different things, actually. We are a different law in that we are not on billable hour at all, which, quite frankly, I really like. Despise filling out timesheets for the first 6.5 years there. One benefit is we look at ourselves as consultants, really. We sit down with a client, go over the project, and quote a price. It's not menu pricing of this is what it will cost to do a patent application. What we try to do is give you options. We'll say, this level of service and this work product is going to cost this much, and then here's some other options that might be less costly, conform your business model right now, the stage of your company, and we'll try and save you some costs that way. The other things we do is, one of the other things we do, we'll collect a lot of the fees that we have to pay the patent office up front, but then we'll put clients on either a semi-annual or annual payment plan, so we can spread out those payments over a longer period of time, as opposed to just getting a bill for X thousands of dollars for a patent application the day after we file it. And those are all things that we're happy to work out with people. It's all about the relationships that we have with people and what we're doing. We're very flexible.
Okay, so a question on kind of the algorithm and mathematical formula. So it's kind of like a
couple of months ago, I don't know if you know Pitco, the big asset management firm there in California.
Yes.
So they got a patent for computing a certain financial index, right? So a lot of people in finance were just laughing and say, wow, they patented a weighted average. But I mean, on one hand, we're saying you can't patent formulas and values. Well, it sounds to me that they did. Can you provide a little color on what they might have patented there? Or?
Yeah, I cannot patent a mathematical algorithm, but I can patent a process that uses that algorithm. So somebody else could take the same formula for computing a weighted average using different inputs to calculate an index, and do that without writing a file that puts they had issues. What you can't do is take it and use the specific inputs that they've chosen and trying to copy their inputs. Whether or not that one's going to stand up, I don't know. I'm not real familiar with it. I saw some of the stories on it, but the rule of thumb really is you cannot patent laws of nature or mathematical formula, but you can patent applications. So that's kind of a fuzzy line, not a real clear one to draw, but that's what you can do right now. Yep.
What are some of the most common mistakes that you see startups make that's maybe sort of penny wise and pound foolish?
Yeah, the biggest one on our intellectual property side is under current law, which only is going to be in effect for another couple of months. You have a blanket 1-year grace period to file that application on an invention. The clock starts ticking on that from the first time you publicly disclose it, put in a printed publication, offer it for sale, even confidential. My new super whiz-bang widget that I want to sell, I offer it to somebody on a wholesale basis. They say no. It was under a confidentiality agreement and everything else. That still starts the clock. And a lot of people don't think about that. They think only a public disclosure. But in the U.S., 1 year after that date, if you file an application and it issues as a patent, it's invalid. And in discovery, somebody will find it in a lawsuit. That patent will go away. So it's keeping in mind those days that being proactive with the intellectual property is really important. The other big one that I see that I alluded to earlier, and I've seen it a couple of times, is that everybody gets into a business venture, and we're eternal optimists. That's what we do. And you don't think of the what-if scenarios of things fall apart, how protected on rights, and there's no formal operating agreement. There's no assignment of the intellectual property to a business entity that you've established. And so you're left at the end of the day where 2 or maybe more people have decided to part ways, and they all have equal and undivided interests in the intellectual property, and then you're trying to negotiate how we're going to value it, how we're going to compensate people, and how we're going to try and sell it. And that can be kind of a nightmare.
So to your point about you have a year when you have to sell it, the clock doesn't start ticking when you're exploring the whole process with your attorney. Only when you attempt to sell it.
And you can keep it under wraps, develop it, and make improvements to it, and that's not a problem.
And manufacture samples.
Exactly. Now, if you want to manufacture under a confidentiality agreement with whoever's doing it, you want to do things just like that to make sure that you can point to them and say, look, that wasn't a public disclosure, that was a prototype. This was for, and there's also an experimental use exception that you're using the article, but you're doing it for collection of data and things like that. Other than market research. Market research doesn't help you with that argument. If you're doing it for data to try and improve the product, that is something that can get you around. All of that is changing in March, where we're going to a first inventor to file. And there's still a grace period, but it's a very different setup. Technically still have that time frame in which to do things, but the way way the patent office has said that they are going to interpret the statute is that the grace period really is not going to be a whole lot. So really, before you do anything like that, as a commercial offer for sale, you'll want to file. The other issue too is that we're a 14 jurisdiction in the United States. In Europe, it's absolutely non-litigious and has been for decades, which means you go to a trade show and you publicly disclose this great new product, you better file a patent application at least the day before you go to the trade show. I can tell you, I've had some long nights before trade shows where that's going.
Yeah. What kind of money are we talking?
What you got?
In a master, and we see people that come in and they go, I got this great idea. Everybody's got a great idea. And then all of a sudden, I have friends who said, well, I just spent $60,000, now I have this patent. And I go, well, that's a lot of money. And you don't have any revenue yet, you got a lot of overhead. So when people come to you and I come in and say, okay, I got the best idea in the world, I want you to file a patent, what kind of money are we talking?
I'm going to get the quintessential attorney answer and say it depends.
Okay, I got that.
The technology area, complexity, how crowded the area is. So if it's a really cool invention, but it's really similar to a lot of other stuff that's out there, then hey, this little change is going to be really important.
And that's what most of them are.
Yeah, and that's,
okay.
You know,
so now we've negotiated that price, and so now
that's going to be more expensive. Now, like I said earlier, when we were talking about how we try and keep things down for startups, on a provisional application, if the owner or inventor wants to do the drafting on the specification, the description of the product, that keeps down our costs. We file provisional applications for anywhere from $3,000 for a very simple thing that's brought to us, and where we're basically serving as an editor-in-chief. We go through and say, all right, we definitely don't want to say that for legal reasons. That kind of review at the low end to us basically writing a full-fledged, what would be a non-provisional application. It can be upwards of $10,000, $12,000 just to file it for a really complicated case. I would say the vast majority of them fall in the $5,000 to $8,000 range to file the application for a non-provisional application. The expenses after that can be a little more unpredictable. There's a lot of hard work. We're having a lot of back and forth with the patent office. It can be expensive. When you get an office action, you have to draft a response. When there's there are times when the examiner just doesn't get it, no matter how many times we try and make them overhead it, and we have to appeal, and that's an expensive process also, even though it's an administrative appeal within the office. So the total cost, on a relatively simple device, I've taken a client entirely through the process of issuance for, I was looking at this the other day, and I think the cheapest we've done is probably about $12,000 soup to nuts. But that was for a device where it was not a complicated device, but there was really nothing like it on the market. Really unique, not very much prior art we had to argue about with the examiner. But that $60,000 mark was probably really high for us. We're here in Omaha. Most of us have had experience in a lot of other markets and bigger law firms that came back here for a variety of reasons, mostly to raise our kids and be around our families. And so we've had some great experience that way, but we don't charge East Coast rates, which is helpful. Thank you. Anybody else?
I just got a question on like product names, which you got into a little bit, but wasn't real clear on it. So what happens if there, say, is a website with a company that has a product name or that has a corporate name that you like, maybe not necessarily a product name, and you want to assign a product name to what that website name is? Would there be any restrictions or possible pitfalls in that sort of scenario?
There's a couple of things you have to keep in mind. One is there's causes of action for trademarks. trademark infringement based on the likelihood of confusion. So if I want to use a very similar mark and it's on a similar good or service to theirs, that can cause a problem. If they've got a registration or I'm in the same geographic area, they can sue me for infringing their trademark because I'm creating a likelihood of confusion that somebody will associate my product with them. And that disparages their goodwill. But either way, it takes the goodwill out of their hands. The other one is dilution, which is in the statute, but it's kind of controversial. It only applies to famous marks. So if I want to register Harley Davidson for T-shirts, leather goods, baseball caps, things like that, they've already got bottled up for those or some up to those products. But even if they didn't, because it's a famous mark, they would say, hey, you're trying to piggyback on our notoriety, our goodwill, and we don't like that. And if the court or a jury agrees, yes, this mark qualifies as a famous mark, that everybody knows associates with that, what the product means to have on, then they can go after you also. So those are the two things. If it's kind of an obscure mark that, okay, that's kind of interesting, and we'd like to use it on unrelated goods, you're problematic. Yeah.
What was the acronym you used earlier? UDRP?
UDRP.
UDRC?
Yep. Okay.